everyone. Welcome to Let's Talk Markets with Dave Lauer. I'm Pink, and today we welcome Professor from the William S. Boyd School of Law at UNLV, Ben Edwards. Ben, how are you doing?
Well, thank you for having me.
Yes, thank you for coming. So the Financial Industry Regulatory Authority, or FINRA, is usually the one handing out fines. But just last month, the powerful Self-Regulatory Agency, or SRO, kind of got its own butt handed to it. A July decision by the U.S. Court of Appeals for the D.C. Circuit could ultimately undermine the very core of FINRA's mission. So today we are asking a fascinating question, which is FINRA unconstitutional? And recent court decisions say, well, maybe. So, Ben, can you help us first by defining what the heck all these acronyms mean?
Oh, of course. So FINRA is the Financial Industry Regulatory Authority. I like to describe it as an entity that exists in the liminal space between business and government. So you're wondering, liminal, that's a big law professor word. It sort of means like it's around sunset, and it's hard to tell. Is it day? Is it night? So FINRA is one of these entities. Is it part of the government? Is it not part of the government? It's hard to tell.
I like that word better. I usually say quasi-governmental, but liminal is much cooler.
Yeah, quasi-governmental is a lot of how it gets described. Some other law professors have described it as a fifth branch of the government. So your usual civics lesson will tell you that there are three branches to the U.S. government: executive, legislative, judicial. Well, what are administrative agencies like the SEC? They make rules, so it's kind of like they're a legislature, but they also enforce them, and they have their own internal courts. So a lot of scholars call them a fourth branch. Financial self-regulatory organizations, or SROs, like FINRA, are kind of a fifth branch. They operate under the supervision of the SEC. Some major differences between FINRA and the SEC. The SEC has to have its spending authorized by Congress. FINRA just collects money from its members and then can spend it however it wants. It's not subject to congressional appropriation. It is ostensibly a private club. Where it has the ability to kick people out or kick members out. The thing that makes it a little bit unique is that in order to operate as a broker, or to buy and sell securities for other people, you have to be a member of a national securities association. And now the only one that exists is FINRA. So
that goes back to the acts of 33 and 34. Is that right?
Yes. Well, sort of. It does. So the securities laws got passed in the wake of the Great Depression. Originally, the New York Stock Exchange had been a self-regulating body, and there was a concern that it had behaved improperly, and so it got brought under SEC oversight. Well, there are a lot of brokerage houses that weren't members of the New York Stock Exchange. So in 1938, Congress passed a new piece of legislation called the Maloney Act, and it created authorization for a national securities exchange or a national securities association for broker dealers that weren't members of the New York Stock Exchange or the other big exchanges. And so that led to the creation of the NASD, which is the National Association of Securities Dealers. The NASD is now defunct, and the new entity that the NASD morphed into is FINRA. That happened in, I believe, 2007.
And people might not, they might be like, NASD, that sounds really familiar. Why would I know that acronym? And it turns out NASDAQ was the automated quotation facility from the NASD that attempted to compete with New York Stock Exchange and then ultimately became its own exchange. And FINRA kind of was the agglomeration of the New York and NASDAQ broker compliance, I guess, groups.
So when FINRA got created, the New York Stock Exchange had its own regulatory arm. And FINRA was created out of a merger of the New York Stock Exchange's regulatory arm and the NASD. So it created this new entity.
Right.
So if you're a retail investor and you have a problem with your broker and you want to fight with them about it, you can't go to court. Right now, when you sign your account opening agreement, there's going to be a pre-dispute arbitration agreement. and that is going to designate the FINRA forum. So securities disputes for retail investors, what I like to call intermediary disputes, are almost always going to be in FINRA arbitration. So it's an arbitration forum overseen by FINRA. And the benefit of it is, if they can't stall you too long, if you win in that forum, FINRA requires brokerage firms to pay within 30 days after appeals or other things are exhausted. Or if they don't pay, they kick them out of FINRA and they're functionally dead as a business.
So you've got FINRA, which is a self-regulatory organization. It's the National Securities Association, which is a special designation in our laws, and something that has to exist, right? So there's a law. You absolutely have to have a National Securities Association. We have other self-regulatory organizations. So the stock exchanges are all SROs.
The exchanges are SROs. So if you want to look at this yourself, you can Google SRO rulemaking, and you can get a list of all the different SROs that the SEC supervises and their pending rules and regulations. So there'll be a lot of exchanges. There's a wide slate of entities that are overseen by the SEC as SROs.
Right, and so that's the SEC essentially. That's the SEC delegating authority in some ways, and that's something that we're going to talk about a bit. But while we're just, I love history, so I will tend to harp on these things a little more than maybe anyone who's listening is interested. But sorry, that's what I'm going to do. But the history of the SRO, it kind of makes sense, right? Like it kind of makes sense in a world in which you didn't have the sort of level of communication and expertise that you have today. Is that your feeling? Like at least a lot of people will sit here and wonder, why does any of this exist? Why doesn't the SEC just oversee everything? And that's the question we can get to as it relates to the present day in a bit. But from a historical perspective, it kind of does make sense.
Yeah. So originally, the SRO structure was born out of a compromise. The New York Stock Exchange didn't want to be totally overseen or brought into the SEC. Or controlled by the government, so it agreed to oversight. There's this famous William O. Douglas quote that I like, where the original role of the SEC, as he put it, was to keep a well-oiled shotgun behind the door, ready to be used in case the SROs got out of line. And so a lot of times you'll see references to the SEC shotgun. The idea is that the SEC is supposed to be keeping a close eye on these SROs and making sure that they, operate in the interest of investors and not just the industry.
So now let's take our time machine, closer to present day. And before I know we're going to talk FINRA and we're going to talk this case and all, but I don't know. I love talking SROs and conflicts of interest. It's kind of my thing. So do you think I don't know if you want to comment on whether you think the SEC is doing a good job of that, but do you think that the SEC even can do something like that in this world in which you now have for-profit self-regulatory organizations, which I don't know that anyone ever really conceived of when they were creating this system?
Oh yeah, so this system has, to be really clear, the system we have right now is not something that anybody at the Constitutional Convention thought about and planned for. It is something that was born, out of compromise and history and, things getting tacked on, over time. So the conflicts of interest you mentioned in this space are very different. Normally, the idea for a regulatory agency is that you want to, pull it away from the industry a little bit and give it some independence to free it from those conflicts so it can regulate more in the interest of the public. An SRO doesn't take that approach. The idea is to let the industry largely regulate themselves. And historically, they've been very good at cracking down on things that reduce their profits. But outside of that, the record's been more mixed.
Mm-hmm. Yeah, I mean, I think we've seen a shocking level of, let's say, controversy and fines over the last couple of decades. In let's say in this new millennium, it's been a pretty checkered history of massive controversies from broker dealers fixing and manipulating markets, whether it's LIBOR or metals or retail brokers ripping off their customers, not getting best execution, that kind of thing. And it's not always FINRA that seems to be finding it, although they're often sort of coming along when it's, let's say, an attorney general or the DOJ or the SEC.
Yeah. So one of the challenges with allowing an SRO to control the enforcement of the rules against its members, I teach legal ethics, and I'll talk to lawyers about how the legal profession supervises itself. I'll ask them, a few years from now, you're going to graduate and you're going to be a member of the bar. I'm going to come to the bar and I'm going to say, folks, would you like to charge yourself an extra $1,000 in dues every year so I can hire some cops to crack down on any misconduct, to investigate what's going on? Are you going to be excited for that? And historically that hasn't, that's been the case. So FINRA, it does play this enforcement role, and it does provide a certain level of enforcement that's probably more vigorous than most, if not all, state bar associations. But that incentive is always there.
Mm-hmm. Yeah, I mean, I think FINRA is there to police broker dealers, is funded by broker dealers, and I do think there is a fundamental conflict of interest there. I will say again, I've disclosed this before. I sit on a committee as a sort of representative of the public interest. It's an advisory committee, has no authority or power at FINRA, but it's the market regulation committee. And I often say these same things to them, that that people feel like they should be doing more, and that there should be more punitive repercussions rather than just fines, which many companies see as a cost of doing business.
Yeah.
Right, which kind of takes us to this case that we're here to discuss right now.
The flip side is there's been kind of, I would call it like a one-way ratchet of changes to FINRA, in the sense that with the NASD, the enforcement was relatively lax. Madoff was able to get away with an enormous amount. And every time there was a scandal, the SEC would push for more, or Congress would push for more, so the enforcement would ramp up a little bit, or responsibilities would change. And so we're talking about this from the investor perspective or a public perspective. You should know that conversations are going on the industry side, where many of them are saying we miss the good old days where enforcement was not as intense. So I want to try to paint as much as I can, a balanced picture of FINRA. It's an entity that's subject to these different influences, and it also has a lot of pushback from the industry every time it tries to be more vigorous.
Yeah, no, that's absolutely right. I mean, it's funny. It's funny you bring that up, because it's both FINRA and the SEC and Chair Gensler. When I talk to individual investors and I interact on social media, I hear how, why isn't the SEC doing more? Why isn't FINRA doing more? All of this. And then you talk to people in the industry and they're like, Jesus, they need to stop. This is crazy. This is way too much.
So we talk about the SEC a lot, but you have to realize the SEC is very resource constrained. If it were not for FINRA, there is no way the SEC could do its job. The SEC just doesn't have the resources to supervise the market. I think there are about as many employees, at FINRA as there are at the SEC, if not more at FINRA. So it's without FINRA serving as the beat cop, we just wouldn't have the bodies or the ability to do any of this. Congress hasn't given the SEC that much money.
All right, so let's talk about then this case, because one of the potential results is that you don't have FINRA as the beat cop, and so let's talk about why that is. What happened here, and why is it interesting?
Okay, so Alpine Securities has gotten into trouble with FINRA, again and again, over the years. It has had lots of fights. The particulars of what this current enforcement action is about like escape me like at the moment.
Mm-hmm.
But
they did something bad.
They did something bad.
Allegedly.
Allegedly, by all accounts, FINRA is moving to try to push Alpine out of the industry. The idea is that FINRA doesn't want Alpine to be a registered FINRA member anymore and wants to kick them out.
Right. So for all those that don't think that FINRA ever kicks firms out, which is also me, here a firm finally did something so bad enough times that FINRA went to kick them out.
Yeah. So really, this is FINRA's big gun. It's all FINRA has. So if FINRA does, like, all FINRA can do is it can assess a fine, and the choice that the firm has is either to pay the fine or to leave. And so if Alpine, it's not interested in a fine, it's just tired of Alpine. It's not gonna try to do business with Alpine anymore. It's just saying, well, we want to kick you out of the club. Functionally, what that means is that Alpine can no longer operate as a brokerage, because in order to be a brokerage, you have to be a FINRA member. So that's what it's really about. Alpine, while it's facing these FINRA enforcement actions and fighting through the FINRA forum and trying to forestall being kicked out of the industry, it decided to open up a separate front in the fight. And so it filed a lawsuit in the Middle District of Florida, challenging FINRA's constitutionality and saying FINRA is unconstitutional and it shouldn't be able to bring this enforcement action against us. It should be declared unconstitutional.
And nobody's tried this before.
So this argument has been pushed before, but it hasn't succeeded, and it's been a bit of time since this has happened. So what's interesting about this is that the current Supreme Court is different, and the relevant legal doctrines have been sort of trending largely in Alpine's direction, which is to say, they have a much better shot at this now than they would have years ago. So here's an example. There was a recent case called Axon Enterprises, and big takeaway from it is it used to be that if you wanted to bring a constitutional challenge against the SEC or some other entity, you had to fight all the way through the appeals process, in their enforcement action against you. So you had to exhaust that entire line before you could get to courts and make a meaningful challenge. Axon says you can just file in a federal district court right away and have your challenge heard, and that's where we are now. Alpine amended its complaint to take advantage of the Axon decision, and is challenging FINRA's existence.
Okay, so Alpine is saying, you can't kick me out. I'm going to kick you out. You can't even exist. Who are you? You're nobody. You're just a bunch of people yelling at me. And the court's going to say, I hope that you shouldn't even be here and you have no authority. Is that, I mean, that seems crazy given the history that we just went through, talking about the need to have a National Security Association, the sort of various forms that has taken over time. Is it the totality of FINRA, or is it just a particular part of what FINRA does that they're challenging?
So when I read the initial complaints in this action, Alpine's attack is on the totality of FINRA and as to how FINRA is pursuing enforcement against it. So it's both. So what ultimately happens here? There's one way to think about it is what's going to happen. Is Alpine going to win or is Alpine going to lose? Mm-hmm. Now, if Alpine loses, it's the status quo. Nothing really changes. If Alpine is winning some of these arguments, then the question is, well, what arguments are they winning, and how does it matter? Mm-hmm. If the DC Circuit says FINRA's enforcement proceedings are unconstitutional and the way they're structured is unconstitutional, what it would be doing is largely neutering FINRA's power to kick firms out through its regular structure. So it'd have to go back and rework its enforcement structure, or maybe try to figure out some different way to do it that would be constitutional. It would seriously impair FINRA's ability to enforce its rules.
Would that be similar to that decision? Now it's escaping me, but it was about the administrative law.
Yeah,
judge
this is
at
Lucia.
the
So there, I think it was a 2018 Supreme Court decision, and the SEC has in-house administrative law judges. They had been historically appointed by SEC staff, as opposed to by the commission. And in Lucia, the Supreme Court said, well, that was unconstitutional. They should be appointed by the commission. And so the SEC has made some changes, and things continue. Now, FINRA is not the SEC, so its hearing officers are not appointed by SEC commissioners. So it could be that maybe one of the fixes they go through after this is they try to bring their own hearing officers, change their appointment procedure to comply. Okay. In the interim, this would really limit FINRA's ability to enforce its rules. There's also the possibility that the courts could just say, well, this whole structure is unconstitutional, and that would create a lot bigger problems. Yeah.
So would that basically, I mean, is that like a nuclear option? Is that will just nuke FINRA? Do you think it would affect other SROs in how they function?
So last year I published a law review article that I probably written the year before, called Supreme Risk. It's in the Florida Law Review. If you Google Supreme Risk, you'll be able to find it probably pretty quickly. And the argument was that the trend line for Supreme Court decisions and these evolving constitutional doctrines created real risk for SROs. And if Congress, or rather if the Supreme Court were to declare some SRO unconstitutional, it could trigger a financial crisis.
Right.
Because the thing to think about here is what happens if FINRA is deemed void or unconstitutional.
Right.
Now, as before I run through this, what I want to make clear is that I think, or at the time I wrote the law review article, my thinking was the trend lines look like they're going in this direction. I can see this danger. I think it's a low probability risk.
Okay.
Now, it's one of these things where if you're out camping and you decide to sleep under a dead tree, you're probably going to be fine. You'd probably be fine for 3 or 4 years. But in year 6, that tree might fall on you. And so that's why you don't sleep under dead trees. It's like it's a low probability risk, but when it hits, you're dead.
Right.
So this, I thought, well, this is a low probability risk, but we want to be thinking about it so we can try to mitigate it and avoid it. So the danger is if FINRA is deemed unconstitutional, well, what does that mean for an ordinary person whose wealth is tied up in the stock market?
Right.
Like if you want to trade, you need to use a brokerage. So the brokerage has to be a member of a securities association. If the securities association is deemed unconstitutional, what happens?
Yeah.
And so there, as we're getting into this realm of uncertainty, many brokerages might decide to shut down operations until there's some kind of curative legislation. So that could be 2 weeks. How long would it take Congress to fix it? So what happens if the U.S. stock market shuts down for 2 weeks?
Yeah, that didn't even happen at 9/11, right? Like it's a crazy thought, right? And a lot of people I know, I hear it on social media. They're like, oh, FINRA's the worst. They're in bed with the brokers. We should get rid of them. And, again, like I think that there are fundamental conflicts of interest in the SRO model. I think it should be dramatically reformed. I think it should be done. So we should do that thoughtfully and carefully, as opposed to just nuking it through judicial fiat. And, I struggle even to envision like what would happen if suddenly a judicial decision came out that said, yeah, exactly what you're saying.
One way to think about this is that you can imagine, a bicycle, riding down the street, and somebody throws a stick into the spokes. You might not be able to predict exactly, where that stick is going to land, which particular spoke it's going to hit, but you can tell it's probably going to crash the bike.
Right.
It may be that they're able to pull off some kind of miraculous stop, but you're probably headed for some kind of unpleasant tumble. Here you can just see this is a monkey wrench potentially coming at a relatively smoothly functioning financial system.
Yeah.
So this case is looking at FINRA, but let me spell out some others for you. The MSRB, the Municipal Securities Rulemaking Board, also an SRO. Whatever the decision is, it's going to have implications for the MSRB. If it went down differently and it was a MSRB case somehow, and it created confusion to where the bond market wasn't able to offer municipal bonds for a period of 2 weeks or a month, you're looking at municipalities not being able to pay their bills, huge problems. It's another crash kind of situation. It could be the National Futures Association. What happens to the options markets? Whatever happens here.
Yeah, imagine like the futures market, like you can't trade crude oil contracts anymore.
Right.
That would be crazy, right? Like the world would shut down.
Yeah. So they're potentially real problems. So this is not to say that I think this is guaranteed to happen or even more likely than not to happen. Yeah. But how the decision is written, how it is structured. I think one of the important things here to know is that the judges are people, and like any other person, they're going to know some things, they're not going to know other things. If you're a con law scholar, you probably don't know very much about SROs. If you are a federal judge that came, from a non-financial services, background, you may not understand the implications of a ruling here. So I think one of the things that's important is to help the DC Circuit, through amicus briefs and other things, to understand, what the consequences are for a ruling here. This is not to say they shouldn't rule one way or another for fear of the consequences, but that they should be thoughtful about how they go about. So one example might be you could craft a ruling that is immediately effective, or you could try to find some way to give to stay it or to give Congress time to react and get involved. The danger I worry about is if some federal court issues an order deeming FINRA or some other important keystone SRO void and unconstitutional, and then the parties seek an immediate appeal and trying to get a stay, and court doesn't understand it, doesn't grant the stay. Problem.
And so can you walk us through sort of, we're at a certain stage, it's still relatively preliminary at this point, right? Can you sort of walk us through what the next steps look like and how this might ultimately make its way to the Supreme Court, I suppose?
Yeah. So where we're at right now is the DC Circuit, Judge Walker, who's a relatively recent appointee. I believe he's about a year younger than me. And he found that the enforcement structure looked very similar to Lucia, what the Supreme Court had found unconstitutional, and I understand his view. So with that, what he did was he made a decision along with another judge on the panel. It was a 2-1 decision to grant a preliminary injunction. So what this means is that there's going to be time for FINRA to make its case and to argue before the DC Circuit. But when granting a preliminary injunction, one of the things you have to decide is the likelihood of the success on the merits. And so in reaching this conclusion and granting the injunction, the DC Circuit essentially signaled that it thought that the plaintiffs or that Alpine was likely to succeed on the merits. So if Alpine does succeed on the merits, when all is said and done, then the question is really, well, how do they succeed if they do succeed? And if they win in a narrow way where it affects FINRA's ability to enforce its rules, that's probably not going to have, in my view, systemic market consequences immediately. But if they win, in a different way where FINRA itself is declared void, that's potentially very bad. That is the bad place.
And then do you think ultimately, regardless of what happens, that decision will get appealed?
Oh yeah. This decision is going to go to the Supreme Court. So if FINRA loses, it's going to appeal. Right. If Alpine loses, it's going to appeal, because so this is where we're at right now. Is an existential threat to both entities. So if FINRA wins, Alpine is done as a brokerage. It's out. if Alpine wins, FINRA is facing, potentially, severe restriction in its enforcement power or more.
And it's just wild to me that it's just coming from a firm like Alpine, which is just a consistent, violator of the rules, consistently fined, and yet they're the ones who might result in FINRA being declared null and void. And we have a Supreme Court that has shown, let's say, a willingness to blow things up.
Yeah. So one thing that's I think is worth reviewing is the Free Enterprise Fund decision. So it was, in the aftermath of the financial crisis, Dodd-Frank, the SEC created the PCAOB, the Public Company Accounting Oversight Board. Mm-hmm. And the way it was structured was that the SEC would appoint members of the PCAOB's governing board. And the idea was that you wanted the PCAOB members to operate independently, so you give them protection from removal. So they have for cause removal protection. So it's kind of like tenure for their term. So the Supreme Court took the view that was unconstitutional because it created too much insulation from presidential control. So you had the SEC, which according to the Supreme Court had for cause removal protection. Now there is no Supreme Court decision that finds that, and there's nothing in the statute that says that. But the Supreme Court just sort of
they're just like, it must be there. Yeah, it's somewhere.
The parties had accepted it. So on that basis, it then found the PCAOB, which did have clear for cause removal protection, was unconstitutional because it was double layer insulation. So at that time, conservative groups sought to bring FINRA up before the Supreme Court and actually filed a cert petition, and they were unsuccessful at getting that case to the Supreme Court. When that case was decided, I think it was in 2010, 2011. Justice Kavanaugh was then a DC Circuit member, so he wasn't yet a Supreme Court justice, and the case was coming up after he had written a dissent in the DC Circuit decision. So the Supreme Court partially agreed with Justice Kavanaugh, finding that the double layer protection was unconstitutional. But Kavanaugh would have gone much further and found the entire thing unconstitutional under the Appointments Clause. But Chief Justice Roberts, writing for the Supreme Court then, did not go that far.
And was that a 5-4 decision?
I believe so. It was either 5-4 or 5-6. So Kavanaugh is now on the Supreme Court, so that vote is different. And Justice Roberts, if he didn't want to go that far, may not have the votes. Yeah. So it's just a very different Supreme Court now, and so I don't know that it would turn out the same way. So Roberts distinguished the New York Stock Exchange from the PCAOB, and the idea was that the PCAOB was this government created and government appointed entity with expansive powers to govern an entire industry. Mm-hmm. Now FINRA or the New York Stock Exchange before then was not government created, and it wasn't government appointed. Now, where it gets a little delicate is that if they're exercising government power and they're not government created and they're not government appointed, is the distinction really ultimately meaningful? I guess so. So one way to think about it is you could have the government create an entity and then appoint people to it, or it could tell the industry that it has to create and register an entity, and then the entity exists. So isn't that what the government
isn't that what the law says?
Yeah. Yeah. So the law requires a national securities exchange to exist,
right?
In order for people to operate as brokerages. Now, that the law required them to form an entity on their own versus the government just forming the entity itself. It's largely a ministerial action.
Okay.
So I don't know that the current Supreme Court would see that as a really meaningful distinction and worth saying this is constitutional. So the underlying concern is that you want to have presidential control over these kinds of entities so that the president can ensure that the laws are faithfully executed.
Right.
And if you don't have any power over any of the board, then how do you control it?
Do you think one likely possibility here could be that it does go that far and that ultimately the Supreme Court says, you know, this doesn't make sense, you can't do this, and that the answer ends up being, well, okay, I guess that just means that the SEC is the only enforcement authority out there and that you can't have other enforcement authorities?
That is one way this could all resolve. It could be that FINRA is looking at, you know, down the road, if this comes out in favor of Alpine, that it's going to have to restructure its enforcement.
Mm-hmm.
And so it could be that it'll have to do enforcement through federal courts, or it could be they would have to do it through the SEC's administrative law court, which is also a federal court. You know, ultimately, how this shakes out, it's really just going to depend on the decision.
Okay. It's funny. There's sort of an analogous situation playing out today with the SEC and one of the proposed market structure rule changes that came out, which is the regulation best execution. And the SEC, which does not have an actual best execution rule, and up until now, it has been an SRO function to police best execution. And the SEC came in and said, well, you know, we need our own for reasons that, you know, like they said, oh, we should just have it. Right now, it happens, you know, we enforce, but under anti-fraud, that doesn't make sense.
Right.
You know, but really, you know, some of the undercurrent of it is that the SRO isn't actually enforcing best execution, and, you know, maybe the SEC would come in with more robust enforcement.
Yeah. So one of the rationales for, you know, the separation of powers argument or the appointments clause argument here is that you want to have your enforcement authorities responsive in some way to elected and public officials.
Mm-hmm.
And so
feels like something a lot of people should be able to agree on.
Yeah.
That sounds bipartisan to me.
Yeah. So, then the question is, well, okay, if that is the case, who's going to pay for it? Right now,
right.
The SEC doesn't have the resources.
Yeah.
You know, the industry has funded all of this through fees and membership fees, and so the public does not, public tax dollars are not currently used. So a lot of times you'll hear this justification for the SRO model that it's ultimately a savings, to the taxpayers.
Yeah.
And I agree to an extent that, like, the government isn't directly spending money on it. But then the question is, well, how is the industry making its profits? If the industry's profits are, coming because of, rents or,
yes, exactly.
Conflicts of interest. Or
the industry loves to shift from explicit costs to implicit costs because implicit costs are far harder to understand. They're not competed over, generally speaking, and they're,
right.
So hand wave it away, right?
So a loosely regulated and self-regulated industry with rampant conflicts of interest may cost ultimately more than public enforcement. Now, then you have this separate question of, okay, well, if we go to public enforcement and this is all running through, the SEC or some other, public regulatory agency, it's going to be subject to the congressional budget process.
Dear Lord.
And
which works so smoothly.
Yeah. So can Congress do this? Can it reliably do this? So here's like one of the major, the major reasons why the United States is a global superpower is because of our financial markets. We have the richest and deepest and most powerful financial markets in the world. If they don't run anymore because Congress can't appropriate enough funds or gets too politicized, that is really bad, both for our financial system and for the United States. So the financial system is really important because in many ways you can think about it as like the lifeblood of our economy, or our ability to run projects, raise money, do things, and organize ourselves. It depends on people being able to raise money and be able to raise capital. And if our markets, we lose a lot of enforcement, or we lose a lot of regulation and oversight because of it. If the markets are just teeming with fraud in the aftermath of something like this, then investors aren't going to risk their money.
Or they're going to move to other places.
Economic growth.
Right?
So this is a lot of danger here.
Yep. Understood. Well, look, I think this has been a great conversation. Very much appreciate you taking the time and your perspective. The situation is a bit scary. It sounds like there will be some more opportunities to talk in the future as it continues to wind its way through. So hopefully we can get you back on as there's some things to update.
This is not going away. This is if it's not this case, then there will be other cases. Now that this challenge has shown it has perhaps some legs.
Yeah, that's right. All right. Well, let's hope that FINRA can figure something out here, and that they figure out a way to kick firms out, because that's, I think, a really important deterrent, much more so than just large fines.
If you say, okay, well, we're going to give you a large fine, and the firm says, all right, I see you've sent me this bill. I'm not going to pay it.
Yeah.
and then it's like, okay, well, we're going to kick you out. Oh, wait, we can't do that.
Nope.
If they don't have the ability to kick people out, then they don't have the ability to collect their fines. And so it's sort of, the risk here is Alpine's trying to knock FINRA's teeth out. And FINRA needs some teeth in order to be able to control the market. And if it doesn't have the ability to enforce, it's going to be very challenging to regulate.
All right. Well, let's see what the courts end up doing. They tend to be a little less predictable these days. So, this is going to be an interesting story to follow. Thank you, Ben Edwards from UNLV. And thank you, everyone, for listening. I hope you enjoyed this episode of Let's Talk Markets. We're going to be off next week. I am taking a little time off. It's August. There's not that much to talk about. So we'll enjoy that. And, you can go listen to some old episodes if you'd like. As usual, hit that subscribe button, and also just, maybe you try to hit the beach too. As I like to sign off, as the late, great Bob Barker used to tell us, help control the pet population, have your pet spayed or neutered, adopt, don't shop, and join us for our next episode of Let's Talk Markets in a couple of weeks. And thanks again, Ben Edwards.
Thank you.